When the Law Society of Upper Canada decided to sponsor a one-day workshop on basic problems in evidence, the response was somewhat larger than was anticipated, and the program was therefore subsequently repeated. The workshops took the form of a lecture followed by a panel discussion in each of the morning and afternoon sessions. The panel discussions were, however, a little out of the ordinary. They consisted of a number of short TV scenarios, each of them followed by a panel discussion examining the various evidentiary problems that arose. In the second workshop, the panels were switched around a little so as to give some variety in opposing views. Both sessions were recorded on videotape, and these programs are an edited version of the discussions of the evidentiary problems arising from the simulated courtroom scenarios. I do not think you will find many clear-cut answers to these fairly common problems. What you will find are discussions of some basic but extremely important principles from which solutions are suggested. This program is designed primarily for the legal profession, though we hope that others will be interested and will perhaps gain some insight into the workings of this aspect of the legal system and the way in which the law tries to reconcile conflicting interests. For the lawyers in particular, citations and references will be given for cases and materials mentioned should they wish to make a note of them. There were in total 4 panels, of which 2 each discussed separately half of the fact situations. On the first day, chairing panel number 1 was the Honourable Mr. Justice Edson Haines of the Supreme Court of Ontario. With him appeared Mr. William Poole, QC, practicing in London, Ontario, and a member of the Ontario Law Reform Commission, and Professor Hugh Silverman, QC, a practitioner of many years' standing, and now Professor of Law at the University of Windsor. Chairing panel number 2 was the Honourable Mr. Justice Thomas Zuber of the Supreme Court of Ontario, and with him were Mr. Clay Powell, QC, Counsel in the Ministry of the Attorney General of Ontario, and Professor Desmond Morton, QC, who is both a practitioner and a law professor at the University of Toronto. Mr. Justice Zuber also chaired the first panel on the second day's program, and appearing with him on that occasion were Mr. Justice Frank Weatherston of the Supreme Court of Ontario, and again Professor Hugh Silverman. Mr. Justice Haines chaired the last panel, again with Mr. Clay Powell and Professor Morton as the panelists. As a result of the editing, panel discussions do not always appear in the order in which they were presented. The last panel discussion illustrates the increasing problem of trying to maintain a balance between legitimate areas of cross-examination and unnecessary and even unfair attacks upon a witness. Witnesses must be encouraged to testify, but they cannot be so sheltered as to inhibit the search for truth. How far can the courts go in its obligation to protect witnesses, both from unnecessary cross-examination and also from having independent evidence called that collaterally attacks them in some way?
Jones is called by the Crown as a witness in a case in which Smith is charged with assaulting Baker and testifies that he saw Smith hit Baker. He is then cross-examined by Smith's counsel.
Have you resided in Ontario? Yes. And have you received psychiatric treatment either as a outpatient or inpatient in a psychiatric hospital?
Do I have to answer that?
My Lord, with respect, I don't see any relevance in this at all.
Well, my Lord, I wish to show that this witness has received psychiatric treatment in a mental hospital and is suffering from mental disease which would make his testimony completely untrustworthy.
This is an invasion of my privacy. If my friends find out, I'll be ruined.
Professor Morton, does a witness have any right to privacy at all? I think this is perhaps a good one to finish on because it deals really with ethics rather than law. It deals with the propriety of asking a question in cross-examination unless you've got a valid reason and a valid factual basis for asking it. I remember in that famous English case where there was a pretender to a peerage, Dr. Skeffington was appearing for the pretender, and he asked every witness, was it not true that he had committed adultery with his wife's sister? And the supply of witnesses dwindled very quickly. Skeffington was subsequently disbarred for asking that question because he had no factual basis for it at all. Now, I don't think that Carter in this vignette would ask this man if he'd received a psychiatric treatment merely to point a finger of scorn at him or to humiliate him. I think, on the other hand, that if Carter in that vignette had a psychiatric report showing that this man was suffering, say, from an acute form of paranoia, in which he felt persecuted and lost and or perhaps was hallucinating all the time and was hearing voices, this might be very relevant to know that when the man was in the witness box, he was in fact only a medium of communication. He was, so to speak, on cable to some other source. I think if I were the counsel, I'd rather like the judge to know that he was merely relaying information from some other source. I mean, I saw Mr. Justice O'Leary recently in Weekly Court dealing with an applicant who was obviously hallucinating while he was there. He was complaining about the messages that were being received. He was dealt with courteously and firmly, but clearly it was helpful to know this. Now, I think it would be a highly improper question to hold this man up to ridicule, and of course in my own opinion there is no necessary inference that a person will not tell the truth about bananas on the floor just because they think they're Napoleon.
Well, as I understand Professor Morton's answer then, it's... This is always the kiss of death when you say, as I understand your argument, it's so-and-so. But as I understand him, it's all right to embark upon this type of attack of a witness as long as you're assured of success, if you have the report in your hand. But I'm wondering if that's the criteria for embarkation upon a line of cross-examination. Suppose you have some basis to suspect. You don't have any medical reports, but there's a fair chance that you might hit pay dirt. Can you then go after a witness on the grounds that he is mentally unstable and thereby unable to correctly recount the events? What do you think, Clay Powell? Can you give it a try?
Well, I think the issue really arises the question whether or not the witness is competent to give evidence in the first place. Recently, in a murder case I was involved in, the main Crown witness, a woman, had been receiving psychiatric treatment, and a challenge was made when she was called as to her capacity to give evidence. And then it was necessary the judge ordered, and I think properly so, that records be produced, and a voir dire was held on that issue. So I think if that be the question, that's one thing. Now, if you're getting in, and this is a proper question that my friend Carter has put, then we seem to fly in the face of, say, judgments in the Court of Appeal like Kaselka, which was a rape case of a young girl where the Crown called a psychiatrist to say she's the type of person who wouldn't make up a story. And one then gets into this type of conflict, and if it's what's fair one way is going to go the other. And so to my way of thinking, it's not a proper area to get embarking upon on this issue, because it just leads the whole trial into who can bring the most people in to vouchsafe for their side of the case.
Well, let me ask you this then. If we concede that the Toohey case is right, in Toohey, one party can call a psychiatrist to say that one of the opposition witnesses was unstable and therefore should not be believed. If you accept that you can bring in a psychiatrist to condemn a witness, why can't you then ask the very person himself whether or not he's the subject of these psychiatric difficulties? Wherein lies the difference between doing it directly or indirectly?
First of all, I don't know that the TUI is the law here, quite frankly. I still think there is this judgment in Kaselka. I have difficulty with those two type situations. But on the other hand, I think that there's a duty, a responsibility to a witness being brought into a court, and to start delving into that type of an issue, I think would. How many people today do have somebody in their family or have problems and been treated for certain types of things? And if that's going to become an issue, just to blacken the person's character, because to a jury, a person who's had psychiatric treatment or something, they're going to say, oh well, he's a nut, sort of thing. And I just don't think it should happen. I don't think it's relevant. And I think we should do everything we can to oppose the introduction of that type of evidence. I appreciate the TUI case.
All right. Before we get too distracted, though, we can get concerned about the witness. Professor Morton, suppose you're defending somebody for, say, capital murder, which is pretty serious as well, and you have reasonable grounds to suspect that the key witness against him has had substantial psychiatric difficulties in the past. Now, I'm just wondering how we balance these interests. Don't you as defense counsel have a duty to sail into this witness and let the chips fall in order to protect your client?
Well, I have no doubt of that at all, provided there is, it wouldn't be enough for me to go on my layman's knowledge of the significance of a psychiatric diagnosis, or indeed the patient's own knowledge of. Many patients don't know why they're in and don't know the extent of their own illness. It may be less serious or more serious than they know. So I would regard this line of questioning only as proper only if you had an expert who is prepared to give evidence as to their condition, as to why they were in, and as to how it would affect their credibility. Now, whether or not I could call that expert might depend on other things, but I would want to know for my own purposes, I would want an expert to instruct me as to the significance of whatever had caused them to be brought in for treatment. It would clearly be proper. In my fairly extensive experience at Penitang, I have on a number of occasions dealt with patients there while they are hallucinating. That is, in response to a question from a psychiatric member of the board, are you hearing the voices now? The answer from the patient is yes, I am hearing the voices now. So I can conceive of situations where someone, particularly schizophrenic, you simply have to bring it out.
But surely that person shouldn't be permitted to give evidence in the court, sworn testimony. They're not competent to testify. There's a case by the name of Dunning, for what it's worth, D-U-N-N-I-N-G, in the Court of Criminal Appeal in England in 1965, where there was 3 accused charged with murder. The main prosecution witness had been found unfit to plead 2 months before the trial on a charge he was facing. But his evidence was admitted after 2 doctors had given evidence that he knew the nature and sanction of the oath. His evidence, but they said his evidence might be unreliable in relation to it. Now, they also, there's a question raised there. They say any examination of the witness should be done in the presence of the jury, which was contrary to the practice followed in a particular case I was involved in. They said that is something that should be done when the jury are there. But I would think it would go to that person's capacity to testify if they're simply hallucinating.
Well, it could be. Supposing they get by that hurdle, though. He's in the witness box. He's already given his evidence in chief, and no one has raised the issue of his lack of capacity, and he's told his story. Now, can you embark upon this attack to destroy the evidence that he's already given?
I think there is an area where he would pass the test of competency, and nonetheless it would be your duty to explore the reliability of his evidence. To take a capital murder case is not really perhaps very fair in this area, because it is rather easy to say, yes, I would do it with that much at stake. I think it would be a deplorable thing if this type of questioning spread so that in every routine civil or criminal case this line of questioning was explored. I think it could not accomplish very much, and at the same time could do a very great deal of harm. I would hate to see this line of questioning become commonplace.
A 5-minute question, and then we should take an hour on it because of the implications involved. We heard Clay Powell talk about the problems of the administration of justice. If you want to make a note on the question of psychiatric evidence as to credibility, you'll find that Professor Mewett has done a magnificent job in 13 Criminal Law Quarterly, page 79. And it seems to me that we are now faced, whether we like it or not, with a very simple question: what are the rights of witnesses? And are they entitled to protection? Now, you start out with this proposition that we have the rights of the accused before the court, and he shouldn't be improperly convicted by one probably who was hallucinating and in bad shape and can't recall anything. On the other hand, you have the right of the witness, who should not be destroyed unless it is absolutely essential to the administration of justice. And I think I've said enough about psychiatric evidence to know, or to indicate to you, my fears about allowing psychiatrists to talk about the essential ingredients of the testimonial capacity of a witness to observe, to recollect, and so on, because often all the psychiatrists are doing is just guessing. But this question of the protection of the court, I throw out to you. Have we not arrived at the stage where we have a real hazard in our province, in our country, of witnesses not coming forward because of the fear of what we do in the courtrooms? I wouldn't have believed that anything could have happened such as happened to Ruth Genovese in New York some 7 years ago when 36 people heard her screams as she was murdered and no one called. But last summer we had the same thing, and we said it was public apathy. I wonder if part of that is the way we treat our witnesses. And I wonder if in addition to that is that here we have a poor old fellow who did his role very well. It may have been that he'd been in and out of mental institutions many times. I can tell you one thing, that 1 in 9 in every family have had emotional problems and have probably been hospitalized. And the people in the past have always been able to go to their psychiatrist and talk in confidence and get help. And the wonderful advantages of chemotherapy and the things that can be done. Now, what's going to happen to the administration of justice, to the witnesses themselves, when someone says to the witness, when were you last in psychiatric hospital? Did you ever have shock treatment? Did you ever have treatment from any psychiatrist or from a doctor? Did you get certain pills mentioning certain drugs and so on? Up until that moment, nobody knew about it. Now the whole community knows about it. And we heard, I think in the last election, what was his name? Eagleson or something like that down in the state?
Senator Eagleton.
Turned out that he'd had, what, some shock treatment or something like that? He'd probably become depressed and they gave him some shock treatment. He was ruined. I go a bit further. Take any man in high office today, any kind of office, and it's necessary for him to go to a psychiatrist. And then somebody in the witness box says to him, have you ever had psychiatric treatment? He may have to resign his position if he has. I don't know. Now, it's only because it's drinking time that I'm going to cut this off, but I want to throw one last thought out to you. I think that the witnesses have the right to have counsel to protect them. The common law supports it vaguely, but I want you to take one look at the Canadian Bill of Rights, because up until now we've been grudgingly interpreting those rights, but lately we have started to extend them, haven't we?
Not too much.
Well, all right. As these brilliant lawyers that you're talking about, let's take a look at Section 2, D. No law of Canada shall be construed or applied so as to, D, authorize a court, tribunal, commission, board, or other authority to compel a person to give evidence if he is denied counsel, protection against self-incrimination, or other constitutional safeguards. Certainly, speaking for myself alone, when this situation arises, I'd like to have all the help possible, to have his lawyer there to raise the issues and to protect the man, because it seems to me that we've got something now arising, coming right up in front of us as to what we should do. You want to say anything about that, Clay?
No, I just make one last comment. It seems to me, I read with great interest the act respecting the right to privacy, the other day, just passed by the government's concerned about privacy, but I don't see anything about this. I see a lot of limitations on the police, but I don't see anything relating to this type of privacy.
In other words, they protect the telephone conversation, but not what goes on in the psychiatrist's office. Is that it?
It seems that way.